3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files.
It's good to be here.
You know, we have spent a lot of time in our previous dives talking about the man himself. We've looked at the crimes, the network, just the sheer horror of all the accusations.
Mm-hmm.
But today, I want to pivot a little. I want to talk about something that feels a bit less tangible at first, but is actually the most concrete thing we have left. I'm talking about the paper trail.
And calling it a trail is almost, well, it's a disservice. It's more like a paper mountain or paper avalanche, maybe.
Exactly. An avalanche is a good word for it.
Yeah.
Because we aren't looking at a neat stack of folders sitting on a desk somewhere.
Oh, not even close.
We are looking at millions upon millions of pages. And it's not just the pages, it's a labyrinth of bureaucracy, these heavy redactions that are everywhere.
Black ink everywhere you look.
Right, and you're just hoping to find these little hidden gems, but they're buried in all this digital noise.
Yeah.
And the system itself, it seems to be fighting against transparency at every single turn.
It does. It absolutely does.
It's just not about one man anymore. It's about the sheer volume of evidence that was left behind and the struggle to make any sense of it all.
And that, I think, is the central mystery we're really tackling today. It's an epistemological problem, as much as it is a criminal one. How do you find the truth when it's buried under a literal mountain of administrative paperwork?
Yeah, how do you even begin? How do you spot a smoking gun when it's hidden inside a terabyte of, mundane invoices and legal motions?
You need a map. You need a methodology.
So here is the roadmap for today. We are going to do something a little different. We're ignoring the headlines. We're ignoring the gossip, the rumors on social media, all of that. We are looking strictly at the raw material. We're going to cover how you can actually read these specific file dumps.
How to navigate them.
Exactly. And we're going to classify the document types. I mean, everything from really boring FAA flight logs to what investigators call trash pulls, which is, well, it's exactly what it sounds like.
It's as gritty as it sounds. We'll also look at the patterns that start to emerge when you stop reading the text itself and you start looking at the metadata, the data about the data.
And then finally, we're going to give you a methodology. If you're a researcher or maybe just a listener who wants to navigate the DOJ releases on your own, this is your guide. We're going to teach you how to hunt.
It's time to dive in.
So let's start with the first piece of evidence, which is, well, it's the nature of the database itself. And this is where it gets really interesting right off the bat, because when we talk about the Epstein files, we aren't just talking about, a static library of PDFs sitting on a government server somewhere, are we?
No, absolutely not. And this is such a crucial distinction for people to understand. We are dealing with a volatile archive, a moving target.
Volatile. What do you mean by that?
The source material we're discussing, it comes largely from the U.S. Justice Department's investigation files. Now, usually when the government releases files, they stay released. It's part of the public record. It's supposed to be permanent.
Sure, that makes sense.
But here, there's this twist in how these specific documents have been handled that is, frankly, very unusual.
Okay, right. I saw this in the notes and I had to read it twice. The release and delete phenomenon. Can you unpack that for us? Because that sounds confusing.
It is confusing.
I mean, honestly, a little suspicious.
It is. And for archivists, it's deeply disturbing. But it's exactly what it implies. The DOJ began releasing documents related to the investigation files that were, ostensibly cleared for public view. But then researchers, journalists, people who were watching the feed very closely, they noticed something strange.
What'd they see?
They would release a batch of files, and then a little while later, some of those files would be deleted. They would simply vanish from the public access points. Gone.
That feels so counterintuitive for a public release.
Mm-hmm.
I mean, if you release it, the cat's out of the bag, isn't it? Why
Right.
would you delete it? Is this just incompetence, someone uploading the wrong file? Or is it malice?
Well, it's hard to ascribe motive without being in the room, right? But the effect, regardless of the intent, is chaos. It creates uncertainty. It undermines trust in the process.
I can imagine.
And it necessitated the intervention of third-party archivists. Specifically, you have to look at databases like the one compiled by the Courier newsroom. They realized that To preserve the historical record, they essentially had to scrape the DOJ site continuously.
So they were just downloading everything as soon as it appeared.
Immediately. They had to retain these files before they vanished into the digital ether. They couldn't trust that what was there one day would be there the next.
So we have third parties, journalists, archivists, basically acting as the safety net for official government releases. That is a pretty precarious position for history to be in.
It's incredibly precarious.
It reminds me of, the burning of the Library of Alexandria, but in slow motion and digital. And I have to ask, when things get deleted, my immediate instinct, and I think the listener's instinct, is to ask what was in them. Was it just formatting errors?
Yeah.
Duplicate pages being removed, that kind of thing?
And sometimes, yes, you do get administrative errors. Someone uploaded the wrong version of a PDF or a page was scanned upside down. That happens. But not always. And this is where we have to look at the database descriptions themselves. They specifically note the existence of deleted items that connect Epstein to very high-profile figures.
High-profile figures. So we're talking about the names that everyone speculates about.
Correct. For instance, it's factually noted in the database description itself that documents detailing connections to Donald Trump were among those items that were deleted and then had to be restored or archived by these third parties.
Okay, let's just pause there for a second. That immediately raises the stakes. We are not taking a political side here at all. We are just looking at the mechanics of this release.
Purely the mechanics.
But the fact that a document or documents linking a future president was there and then it was gone, and then it had to be saved by a third party, that tells us something really important. It tells us that looking for what isn't there, or what was briefly there and then removed, is just as important as reading what stays up.
Precisely. It turns the entire research process into a form of digital archaeology. You're not just reading a file, you're investigating its provenance. You're checking its status. Is it still there? Was it modified? Why was it pulled?
It adds this whole other layer of complexity to what we're calling the haystack.
It does. You have to constantly ask yourself, was this document deleted because it was irrelevant, or was it deleted because it was too relevant? And the system doesn't give you an answer.
And what a haystack it is. I mean, we keep throwing around this phrase millions of pages,
Yeah.
but I really want to give our listeners a sense of the scale here. We have source documents that specifically address this volume problem.
That's right. And that document is crucial because it highlights the physical versus the digital reality of this entire investigation.
Mm-hmm.
In the modern era, we expect discovery to be neat.
Right, you think of a nice searchable database.
Exactly. Searchable PDFs, maybe an Excel spreadsheet or two that you can filter and sort. But this archive, it is filled with what the legal team themselves describes as unwieldy documents.
Unwieldy. That's a very specific lawyer word. It usually means expensive to review, doesn't it?
That's the subtext, yes. Essentially, it means it's a mess. It's a logistical nightmare. Many of these are scanned documents produced during discovery, so that means someone, somewhere, took a physical piece of paper, maybe it was a handwritten note, maybe a carbon copy of a flight manifest from 1998, maybe a napkin with a phone number on it, and they ran it through a scanner.
Which means you can't always just hit Control F and find the truth. Optical character recognition, OCR, it isn't perfect, especially with messy handwriting or old documents.
It's not, and that's a huge problem. If you are searching for a specific name, and that name is handwritten in cursive on a scanned cocktail napkin, the computer will not find it. A human being has to read it, eye to page.
Across millions of pages.
Across millions of pages. And it gets even more technical. The files discuss something called the embedded file issue, which is a whole other can of worms.
This sounded like a horror story for a data analyst when I first read about it. Explain what embedded files are in this context.
Okay, so imagine you open a PDF file. It looks like a normal document. But inside that PDF, digitally attached, like a paperclip you can't see, are other files. It could be an email attachment, a spreadsheet, an image, even another PDF.
So it's hidden data?
It can be. If you're just scrolling through the main document in a standard viewer, you might see a tiny icon or you might see nothing at all. You could scroll right past the most important piece of evidence and miss it entirely.
So what do you do?
The researcher has to essentially write or extract that data. You need special software or programming skills to pull it out, to even see the full picture.
So it's like those Russian nesting dolls of evidence. You open the big doll, the PDF, but unless you know to shake it and see what falls out, you miss the smoking gun inside.
That is a very apt analogy. And if you don't know that you're supposed to open the next doll, you miss the evidence inside. This creates a massive barrier to entry.
That's our journalists, for the public.
For everyone. It means the truth isn't just sitting on the surface. It's encapsulated. It's buried inside the file structure itself. It requires a whole different level of technical skill to uncover.
Now, anyone who is trying to look at these files has probably noticed the naming convention. It's not very user-friendly. It's not like they are titled Epstein email to Maxwell.pdf or the secret plan.doc.
Oh, if only. That would be far too easy.
That would be too easy.
No. Instead, we see the EFTA prefix across pretty much the entire database. EFTA followed by a long string of numbers.
It's robotic.
Yeah.
It's dehumanizing in a way.
Yeah.
I mean, you're looking at these horrific crimes or, massive financial transactions, and they're all just numbers. EFT 00002015. It means nothing.
It's purely administrative. These are likely what are called Bates numbers or similar identifiers used for litigation support. It's how lawyers keep track of millions of pages without going insane.
So we don't read these IDs aloud for a reason.
Right, because they aren't narrative titles. They're just coordinate points in the database. But understanding why they exist is key. For example, one of the files we looked at discusses the challenge of cursory examinations.
Cursory examinations, it just sounds like skimming.
It is, but it's a legal necessity born of the sheer volume we just discussed. When you have millions of documents and your job is to categorize them, is this privileged? Is this relevant? Is this junk? You simply cannot read every word of every page immediately. It's impossible.
So what do?
The document describes the process of just skimming the first few pages of files to categorize them. You look at the first page, the last page, maybe a few in the middle, and make a judgment call.
So just think about the implication of that for a second. There might be something absolutely explosive on page 50 of a 200-page document. But if the paralegal or the algorithm only looked at the first 10 pages to decide which folder it goes into, that explosive detail gets filed away in a general miscellaneous folder and potentially lost for years.
That is the risk. That is the fundamental problem of discovery at this scale. And that's why independent researchers, journalists, the public, they act as a second wave of eyes. The legal teams do the initial triage. The public historians do the deep reading.
We're looking at the pages the lawyers didn't have time to read.
Or the pages they categorized as mundane because the first 3 pages were just standard cover sheets. The devil is often in the details they skipped.
Okay, let's move on to topic 2, which is the taxonomy of evidence. Because not all documents are created equal, right? Not in the eyes of the law and certainly not in the eyes of history. And honestly, some of this stuff is incredibly dry and some of it is incredibly graphic.
That's very true. And the first and most important distinction we need to make is between judicial documents and mere papers.
I saw this distinction in the sources, and I have to admit, it confused me at first. To me, a paper is a document. A document is a paper. Why does this legal distinction matter so much?
It's a massive difference, and it all comes down to public access. A judicial document is something that has been formally filed with the court and is relevant to the judge's decision-making process. It's part of the official machinery of justice.
Okay.
And in the U.S. system, there's a strong presumption of public access for those kinds of documents. The public has a right to see what the judge saw, to understand how and why a decision was made.
And what about papers?
Papers is a broader term. It might refer to discovery materials that are exchanged between the lawyers but were never actually filed with the court. Or it could be personal notes, internal memos, things that haven't met that high threshold of being central to the judicial function.
So the legal argument to get things unsealed often boils down to this distinction.
Exactly. The argument is often, has this document historically been open to the public? Is it the kind of thing the public gets to see? If not, we might never get to see it, even if it's incredibly relevant to the actual crime.
So when we see a big file dump, what we're usually seeing are the judicial documents that finally won the argument to be unsealed. We're not seeing everything the police have.
Not by a long shot.
We aren't seeing the raw evidence locker.
Correct. You are seeing the tip of the iceberg that the court has allowed to break the surface of the water. There's a whole lot more underneath that we may never see.
Okay, so let's talk about the specific types of documents we do get to see. And I want to start with the error in the trafficking operation. The flight records, these are, they're famous. Everyone talks about the flight logs, but the actual documents are a lot more technical than just a list of names.
They are. We're talking about the FAA files. And these are fascinating because they are so utterly bureaucratic, so mundane on the surface, yet they document something so incredibly sinister. We're looking at things called airworthiness documentation, and FAA designee files.
So these aren't just lists of passengers, right? This isn't just a guest book that somebody signed at the door of the plane.
No, these are highly technical documents. You're looking at Form 805064. You're seeing the signatures of mechanics who worked on the engines. You're seeing the addresses of where the planes were registered. Maintenance logs.
Why does that matter, though? Why should a listener care about an airworthiness certificate for a Boeing 727 from 20 years ago?
Because it tracks the physical asset with incredible precision. It proves the movement of the vehicle. If you can place Epstein's plane at a specific airport on a specific date using an official FAA form, which is a federal record, very hard to fake, and then you have a victim's testimony that matches that exact date and location saying, I was flown to New Mexico on that day, you suddenly have powerful corroboration.
It turns a story into a fact, a memory into data.
It grounds the narrative in logistics. You can argue about what happened on the plane, but it's much harder to argue about where the plane was. You can lie about where you were, but your plane can't lie to the FAA.
That's a great way to put it.
It tracks the physical movement of the air aspect of the entire operation. It's the skeleton upon which all the testimony hangs. You can argue about human memory, but you cannot argue with a stamped form filed with the Federal Aviation Administration in 2002.
So then we go from the pristine world of federal aviation, from the skies to the gutter, literally, the trash pulls.
This is the gritty, unglamorous reality of investigation work. The sources describe law enforcement collecting bags where several notes and papers were found.
Just imagine that job for a second. You aren't flying on a private jet to a private island. You are crouching behind a hedge in Palm Beach in the middle of the night, digging through Jeffrey Epstein's garbage bags.
And you're documenting it meticulously. The files contain these detailed inventory returns. Item 1, shredded yellow legal pad paper. Item 2, handwritten note regarding massage schedule for the week. Item 3, a sticky note with a phone number and a first name.
It's such a stark contrast. On one hand, you have these high-flying FAA documents, all official and federal, representing this billionaire lifestyle.
Right.
And then on the other hand, you have shredded notes fished out of garbage bags, representing the sordid reality of the crime. It really paints a picture of the two lives being lived here, the public facade and the private reality.
And it also shows the desperation to hide information. You don't meticulously shred notes if they are just grocery shopping usually. Yeah. But it also shows a point of vulnerability. This was a sophisticated man. He had servers and encrypted lines, but at the end of the day, he was still putting physical paper in the trash.
It's almost quaint in a way.
Yeah.
In an era of encrypted messaging and disappearing chats, he was potentially defeated by physical trash.
Old habits die hard. And trash pulls, from an investigative standpoint, are often where the most unguarded moments are found. People throw things away when they think they're done with them, when they think no one is possibly looking.
Now, some files aren't in the trash. They are locked behind a big red stamp that says, highly confidential.
Yes, and the sources outline the protective orders for these files explicitly. This is very strict stuff. We're talking about legal orders where individuals have to physically read and sign agreements before they can even view these documents.
And these aren't just marked confidential. The label is highly confidential. Is there a meaningful legal difference, or is it just for emphasis?
It's for emphasis, but it signals the sensitivity. The labeling is aggressive. It's stamped on every single page. The folder titles are marked in bold. It signals to everyone who touches it that the content is likely either extremely sensitive personal information of victims, or perhaps financial trade secrets, or material that could seriously compromise a fair trial.
So it creates this kind of club of people who know the full truth, but are legally gagged from speaking about it.
That's a good way to think about it. It puts the information in a legal lockbox.
One thing that really stood out to me in this taxonomy of evidence was the section on electronic communications, or more specifically, the apparent lack of them.
The anomaly. It's one of the more puzzling aspects of the archive. We have documents called preservation orders that are mentioned in the files.
And these are pretty standard, right?
Very standard. It's a legal order sent to all parties saying, do not delete your emails, do not wipe your hard drives, preserve everything.
Standard procedure. You get sued, you get a preservation order. It's step one of any litigation.
Right. But then we hit a specific source document, which is investigating a claim that there was not a single email, document, or text from Jeffrey Epstein himself found within certain investigative scopes.
Okay, stop there. How is that even possible? This is a man who ran a global financial operation. He was connected to heads of state, to billionaires, to scientists. He was moving millions of dollars around the world. And he didn't send a single email.
That is the multi-million-dollar question. And we have to analyze the implications. Was he incredibly, almost supernaturally, digitally cautious? Did he genuinely never use email? Did he do everything by phone or in person?
That seems unlikely in the modern world.
It does. So the other possibilities. Did he have a server that was expertly wiped just before the preservation order hit?
Or is the collection just incomplete? Did they just not get the right server?
That's the other possibility. It feels like a black hole in the middle of the data. You have millions of pages of these unwieldy documents and physical trash pulls, but this glaring void where the emails and text messages should be.
And that void tells a story too, doesn't it? It suggests a very deliberate strategy of non-digital communication, or like you said, extreme digital hygiene.
An obsession with avoiding a digital paper trail, which in itself is revealing.
Which brings us to someone who is very much involved in the paper trail, often arguing against its release. Let's talk about topic 3, the Maxwell files. This really feels like a case within a case.
Oh, absolutely. Ghislaine Maxwell's legal struggle with the documents is a saga in and of itself. One of the documents we reviewed discusses what we could call the discovery logjam.
And this was part of her defense strategy, correct? The defense team claimed that she was unable to review certain discovery files simply because of the sheer quantity. The volume itself became a weapon.
It's a classic legal tactic. If the prosecution dumps 5 million pages of evidence on you, how can you possibly prepare a defense in 6 months? It's often called the drinking from a fire hose problem.
Or document dumping.
Exactly. You overwhelm the other side with so much information, hoping they'll miss the important stuff. It's a way of hiding the needle by delivering it in a gigantic haystack.
It's basically a denial of service attack, but with paper instead of data packets.
That's a perfect modern analogy for it. And what's more, there was a significant limitation on her access. The files note that she was merely permitted to see certain documents versus actually possessing them.
And that's a huge distinction. If I can only see a document in a secure room for a few hours, I have to try and remember it. I can't take it home with me. I can't spread it out on my floor and annotate it at 2 in the morning with a cup of coffee.
Exactly. You can't show it to an outside expert easily. You can't run your own analysis on it.
It severely restricts the ability to build a defense. It forces the defense to work with one hand tied behind their back. Now, whether you sympathize with the defendant or not, just from a procedural standpoint, that is a significant handicap.
It is. And it shows how the government can use the documents themselves as a tool of control and leverage in a prosecution.
Now, buried within these Maxwell files, we start to see references to a very prominent law firm, Boies Schiller.
This is significant. The files contain numerous references to the Boies Schiller law firm and, more importantly, specific allegations that are found within their own files.
And we're talking specifically about the recruiter allegations.
Correct. The term recruiter of underage girls appears in the context of these legal files. And there's a fascinating and chilling discrepancy noted in the source material, a suggestion that there was more in Boies Schiller's files than he let on.
More than he let on.
Yeah.
That is a chilling phrase. It implies that the legal files from the civil cases, the ones intended to get a monetary settlement, might be holding the real smoking guns that were kept out of the initial criminal court proceedings.
It highlights a fundamental split in the justice system. Civil litigation lawyers often gather massive amounts of dirt on the other side to force a settlement. But that dirt, that evidence, may never see a criminal courtroom because once the case settles, it's often sealed and put away.
So the evidence exists, but it sits in a lawyer's filing cabinet in a skyscraper, not in a police evidence locker.
And it might stay there forever unless a judge orders it unsealed.
And speaking of things seeing the light of day, we have to talk about the 2015 unsealing. For many people, this was the moment the case exploded into the public consciousness.
It really was. This is where we got the infamous PALS list, as the media called it.
We're talking about names like Prince Andrew, Alan Dershowitz, Bill Clinton, the heavy hitters.
Yes, and we must be very careful here and very precise to maintain the neutrality of the documents. These names appear in the context of the files that were released. Their presence establishes an association, or their presence on flights, or their mention in victim testimony.
Right, and this is a key point for anyone doing this research. The documents establish that they were there, or that they were mentioned. They do not automatically endorse every single conspiracy theory you might find on the internet.
Exactly.
But the fact that they are there, in black and white text, in a court document, is what matters. It takes the gossip and gives it a legal footnote.
It moves these associations from the realm of rumor into the realm of documented fact. And once something is documented, it can be investigated further. It provides a starting point.
Okay, let's unpack this a bit more. We've looked at the types of documents. Now I want to look at the patterns. Because when you read thousands of pages of this stuff, you start to see themes, phrases, and ideas that repeat over and over again. So topic 4, reading between the redactions.
One of the strongest and most disturbing patterns is that recruiter narrative we just touched on. But it's not just a casual word used by a lawyer. It becomes a formal allegation within the document metadata itself.
Metadata, again, it just keeps coming up. It's so important.
It's the ghost in the machine. The metadata tags in the databases specifically use the phrase recruiter of underage girls. And we can trace this narrative back a long, long way. There is a document reference from 1996 that purports to document encounters from as far back as that year.
1996. I mean, just think about that. That pushes the timeline back so much further than when the general public started paying attention around, what, 2005, 2006?
Much further.
1996 is pre-social media. It's pre-9/11. That's the Macarena era.
It establishes a long-term pattern of behavior. It suggests that this wasn't a phase he went through in the 2000s. It was an established operation. And the fact that documents exist from 1996 suggests that this behavior was known, or at least recorded in some fashion, for decades.
It wasn't a secret. It was just ignored.
Or kept quiet very effectively.
Another pattern that emerged, and this one is more about the legal process itself, is what you could call jury management.
This is fascinating from a procedural standpoint. There are entire documents dedicated specifically to jury instructions.
And these are the standard warnings, right? Like, don't read or listen to or watch any news about this case.
It seems standard, but in a case of this magnitude, with this level of media saturation, the concern is amplified tenfold. The documents reveal a deep, palpable anxiety from the court about what jurors might have already heard or read before they even set foot in the courtroom.
Because everyone had heard something. You couldn't go to the grocery store checkout line without seeing a magazine cover with his face on it.
Exactly. So how do you find a truly impartial jury when the trash pulls and the flight logs are being discussed on every news channel every night? The documents really show the court struggling with this problem of outside influence. The media saturation acts as a contaminant in the legal petri dish.
And then there's the pattern of silence, what you call the privilege shield.
Yes. The frequency with which plea negotiation privilege is cited in the files is really notable.
Can you explain that for us? Plea negotiation privilege. What does that mean in practice?
Generally speaking, discussions that happen between prosecutors and defense lawyers during the negotiation of a plea deal are privileged. They can't be used against the defendant later if the deal falls through, and crucially, they are often shielded from public view.
So if Epstein's or Maxwell's lawyers were in a room trying to cut a deal and they admitted to certain things, X, Y, or Z, in order to get a lighter sentence, we might never get to see the transcript of that conversation because of this privilege.
Precisely. It is a powerful legal shield that is used to block petitioners, like the press or victims' groups, from seeing specific documents. It protects the mechanism of the plea bargaining system, often at the cost of public transparency. It allows the truth to be horse-traded for years, all behind closed doors.
And alongside that, we also see documents called waiver explanations.
This is the bureaucratic side of that same shield. These are documents justifying why certain legal fees should be waived, or, more importantly, why specific documents are exempt from public release. It's a constant formal tug-of-war on paper between we, the public, want to see this, and here's a legal rule that says you can't.
It really drives home the point that this isn't just a crime story, it's a legal war.
A war fought with paper and ink and redaction stamps.
So we have listeners right now who are probably thinking, okay, this is a lot, but I want to see this for myself. I want to look. How do they do it? Let's move to our final topic, topic 5, a methodology for analysis, a guide for the citizen researcher.
The first rule, the absolute first rule, is verification. You cannot just look at a PDF you found online and assume it's real and unaltered. You have to try and verify authorship and authentication, as it's noted in one of the sources on expert testimony.
The source you're referencing mentions a document analyst, and specifically, it brings up Secret Service involvement.
Yes, and that's not as strange as it sounds. The Secret Service originated as an agency to fight financial fraud, so they have deep forensic capabilities to analyze documents, things like ink aging, paper type, digital metadata in a file. A serious researcher needs to adopt that mindset. Think like a document analyst. Who wrote this? When did they write it? Is the signature authentic? Is the font consistent with the year it was supposedly written?
Be skeptical.
Be very skeptical. And then there's the practical matter of just navigating the database itself. If you're looking at one of the public archives, like the Pinpoint database or the direct DOJ releases, you have to understand the power of the filters. People, organizations, locations, these are your best tools.
And the metadata gives you that geographic spread we talked about.
Right. You see Manhattan, New York, Florida, but you also see U.S. district courts. You see the organization spread, FBI, DOJ, Southern District of NY.
So if you filter by Florida, you get a very different story than if you filter by Manhattan.
A completely different story. Florida is likely the trash pulls, the early police interactions, the local gritty on-the-ground stuff. Manhattan is the federal indictment, the non-prosecution agreement, the financial center, the high-level legal and financial battle. The geography tells the narrative.
And we have to circle back to that delete factor we started with. How does that fit into a researcher's methodology?
This is probably the most psychological part of the work. You have to handle the reality that documents you find one day might be gone the next.
So if you see something important, save it immediately.
Absolutely. Archive it, take a screenshot, download the PDF. Don't trust that it will be there when you come back. And, more importantly, look for those deleted items as a signal of importance. If something was removed, even temporarily, you have to ask why. That might be where the real heat is.
Finally, let's talk about critical thinking. As a researcher, you need to distinguish between, say, a formal indictment and a simple motion.
This is critical. The sources mention a formal indictment. That is a formal accusation that carries the weight of a grand jury behind it. A motion, on the other hand, is just a lawyer asking the judge for something.
So if a defense lawyer writes a motion saying, my client is a saint and this is all a misunderstanding, that's just an argument. It's not a finding of fact by the court.
Exactly. And remembering that distinction we made at the very beginning. Judicial documents generally have a higher standard of public access and reliability than private papers. Knowing what a document is tells you how much weight you should give it. Don't treat a defense lawyer's wish list as a proven fact.
Okay, let's just step back for a moment and look at the big picture. We have unpacked a ton of information here.
We have. It's a lot to take in.
We've established, I think, pretty clearly that the Epstein Files are not a single book you can just pick up and read. They are a messy, redacted, deleted, and restored digital ecosystem.
It's an ecosystem of flight logs, of trash pulls, and of endless legal battles over privilege. It really is millions of pages of unwieldy PDFs. It's a puzzle where half the pieces are turned face down and the other half are just missing.
We learned how to spot the difference between an email preservation order, which is just a command, and the raw and suspicious lack of emails that were actually found. We learned that the EFTA number, that boring string of characters, is your best friend in navigating this chaos.
And we learned that sometimes the most boring documents on the surface, the airworthiness certificates, the jury instructions, can sometimes tell the most vivid stories about how this entire operation worked and how the legal system struggled and often failed to contain it.
It really changes how you look at the news, doesn't it? When you hear a headline that says, new documents released, you know now that that means wading through the metadata, checking for deleted items, and understanding the taxonomy of what you're even looking at.
It is about doing the work. It is about reading the footnotes, not just the headlines.
But there is one big piece of this puzzle we haven't touched on at all today. We've talked about the planes, the paper, the trash, the lawyers, but we haven't talked about the fuel that kept this whole machine running.
The money.
Next time, the money. Following the finances, shell companies decoded. Where did it come from? Where did it go?
That is going to be a deep dive.
That's next time on the Epstein Files.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.